Good afternoon, everybody, and thank you for joining. This is the ASTP HTI-2 proposed rule information blocking information session. My name is Josh Shapiro with Capital Consulting, and I'll be assisting with the logistics support for today's session. If you need technical assistance, please click the chat icon at the bottom of your screen. Type your issue into the chat, and one of our techs will respond to you. Finally, please be aware that today's session is being recorded. Closed captioning is available by clicking the CC icon at the bottom of your screen. And I will now turn it over to Michael Lipinski at ASTP. Michael, take it away.
Hey, thanks, Josh. I'm going to give it maybe a minute or two. I see we're still having folks join. And in the interlude, I'll just introduce myself. So Michael Lipinski, as you see on the screen here, I am the Division Director for our Regulatory and Policy Affairs Division. Today, we're going to be talking just about the information blocking session, and I'm joined by my colleagues, Rachel Nelson, who leads the Branch Chief Compliance and Administration Branch, overseeing the administration of our information blocking regulations and other matters regarding compliance with the certification program. Dan Healy is also joining us, and Beth Quill, both from the Compliance Administration Branch. So with that, and I think that got us a few more folks to join, let's go to the next slide. Our always present disclaimer. So we're talking about a proposed rule today, so we won't be able to interpret that or provide any additional clarification other than what we have done in the preamble of the proposed rule. At the end of this presentation, I will talk to you about how the comment process works. And if you do have any questions or concerns where you think there is some ambiguity regarding the policy, please submit those as comments on the rule through the regulations.gov. Not going to read everything on here for you, and you will get the slides will be posted on healthit.gov later this week. So with that, let's move to the next slide. So here you have the agenda for today. So I'm going to lead it off with a brief review of information blocking, where we were, where we are today, and where we're headed with this proposed rule. And then I'm going to turn over to my colleagues to actually go into detail about each of the proposals in the rule that break out into the definitions, revisions that we're proposing to existing exceptions, and then 2 new exceptions that are proposed in this rule. And then, as I mentioned, I will talk a little bit at the end about resources available and how to submit comments. So with that, let's have a little recap on where we were and are today with information blocking. So we had the, so I take a step back and tell you a little bit about this rule, why we're doing it. So on the screen, the 2 that relate to information blocking are obviously the statutory requirement to identify reasonable and necessary activities that do not constitute information blocking. And then also I'd point out the executive order about promoting competition in the American economy, which we believe information blocking does by making data more available to those who need it when and where it's needed. So with that, now let's talk a little bit about information blocking. Next slide, please. Next slide. Okay, so what you have here is the information blocking definition in its elemental form, I will call it, versus the actual definition as given to us by Congress in the statute. So it breaks out, as you see here, into are you an actor? We define those terms which are given to us by the statute, which are healthcare provider, health IT developer, and health information network, health information exchange. Then you have it has to be electronic health information, which we also defined. And then it has to be an interference. And the point on interference that I want to make always is it has to, if it materially discourages access, exchange, or use, that can also meet the definition. It doesn't have to be an actual interference. We'll talk a little bit about that today when we talk about the particular practices that we believe are interferences and are proposing to codify in the regulation itself. And then obviously there has to be the requisite knowledge. So for healthcare providers, as a reminder again, they have to know that the practice would likely interfere with access, exchange, or use, and it has to be unreasonable as well. When you're talking about HINs and HIEs and developers of certified health IT, that is our definition that we finalize for a health IT developer for purposes of information blocking, then you only should have known that it would likely interfere with access, exchange, or use. And then the two that when it's not information blocking, even if you were to meet all those other elements, or when a law requires that you not share the EHI, and then when we have codified an exception, a reasonable and necessary activity that the department does not believe is information blocking. And that's what we're going to focus on today, as well as more clarity against some of those other definitions. As a reminder, we haven't changed since we finalized the first set of information blocking regulations in May of 2020, I believe it was, and they all actors became subject to them in April of 2021. We have not changed the electronic health information definition, besides the fact that the limitation on it only referencing USCDI expired. We have provided more guidance since that time in HTI-1 on the definition of actors, particularly as it relates to an offering health IT. And then obviously we've provided more exceptions and revisions to exceptions. So with that, let's move to the next slide and just briefly touch on the exceptions. So as you see on your screen here, we're up to 9 exceptions, reasonable and necessary activities that do not constitute information blocking in the HTI-1 rule, which became effective in March, which makes that definitions, any revisions to definitions effective, as well as makes the new and revised exceptions and conditions available to actors. So it's been about 5 months since that time, and those are available now. And in that rulemaking, just as a reminder, in HTI-1, there was some cleanup we did in terms of the content and manner exception becoming the manner exception, but we also did significant proposals related to the infeasibility exception, of which 2 will be discussed again today, because 1, we are proposing some additional revisions to the condition, the third-party modification use condition in the feasibility exception, as well as taking comment on the manner exception, which is a new exception that we codified in the HTI-1 final rule. So with that, we can move to the next slide. I think that's a fair enough summary, and I'm going to turn it over to Rachel now, and we'll focus the rest of the presentation on the proposals in the HTI-2 rule related to information blocking. So Rachel.
And thank you, Mike. I am Rachel Nelson. You can find my name on the title slide of the presentation. Next slide, please. I'm going to talk to you about, first of all, the overview of what the information blocking proposals in HTI-2 are. So there are 3 kinds of proposals for the information blocking regulations. See them here on the screen. Enhancements related to defined terms, updates to existing exceptions, and also 2 proposed new exceptions. Next slide, please. So I'm going to start out with the defined terms enhancements proposals. The rule proposes, I will note before I jump into the healthcare provider definition proposal that if you've looked at the HTI-2 rule, the rule does propose to adopt in the information blocking regulations definition section the same definition of reproductive health care that has been adopted in the HIPAA regulations. That proposal is made and discussed in context of the proposed protecting care access exception, which we will discuss a little later in this session. And now the healthcare provider definition proposal. So we propose on the slide, there's a proposal, and then there's some benefits. Proposal description under the first box, and some, a benefit highlight under the second box. Apologies that the text may not be showing in the box, the words proposal and benefits. So in the Cures Act final rule, we adopted in and for the information blocking regulations a definition of healthcare provider that simply says healthcare provider has the same meaning given this term in the definition section of ONC's authorizing statute. This is section 3000 of the Public Health Service Act, but in the regulation text, we do use its United States Code citation. Same statute, different citation. We now propose to revise the regulatory text for this definition to cite the exact paragraph of the statute where the healthcare provider definition appears, and also to explicitly reference the paragraphs within Public Health Service Act Section 3000 where the terms pharmacist and laboratory are defined. The cited paragraphs in the statute cross-reference other pieces of law, so for ease of reference, we provide in the HTI-2 preamble the cross-reference definition for laboratory and pharmacist. Next slide, please. So we propose to codify that for purposes of the information blocking regulations, both health information technology and its shorter form, health IT, have the same meaning as health information technology in Section 3000 of the Public Health Service Act. The Act defines health information technology as hardware, software, integrated technologies or related licenses, intellectual property, upgrades, or packaged solutions sold as services that are designed for or support the use by healthcare entities or patients for the electronic creation, maintenance, access, or exchange of health information. Because our definition of health IT developer, of certified health IT, and offer health IT as they're currently codified already explicitly reference this same statutory definition of health information technology, this proposal to adopt the definition of health IT in regulation would not change the meaning of either of those two definitions. Another point of interest about this particular definition, aside from its benefit of offering some enhanced certainty about what we mean when we say health IT within the information blocking regulations as a whole, is that in 2020, ONC leveraged the definition of health information technology from the statute in finalizing the definition of interoperability element in the information blocking regulations, though that definition does not use the health IT definition in its entirety and does not explicitly cite it in the regulatory text. The proposal to adopt a definition for health information technology would not change the definition of interoperability element that we had previously adopted in that same section of the information blocking regs. Next slide, please. So we do propose to codify that for purposes of the infeasibility exception, business day or business days means Monday through, so it means what you can see on the slide there. I'm sorry, I'm having a little trouble seeing the slide at the moment. So currently, both the infeasibility exception and the licensing exception include the timeframe provisions that include the term business days. We explained in the ONC Cures Act proposed rule preamble that we consider a business day to include normal work days and hours of operation during a week, Monday through Friday, excluding federal holidays and weekends. Codifying the proposed definition of business days would make this immediately clear on the face of the information blocking regulations text. When might you care which days count as business days? Well, We'll talk more about the infeasibility exception later today. So for now, I will just call your attention to the licensing exceptions negotiating a license conditions. To meet them, the actor must, 1, begin license negotiations with the requester within 10 business days from the receipt of the request, and 2, negotiate a license with the requester subject to the licensing conditions, further in that exception, within 30 business days from receipt of the request. Another point of interest, if you have reviewed the certification program proposals in HTI-2, you might have noticed we also propose to adopt the same definition of business day or business days in Section 102, the definition section of Part 170, so the program regulations, for purposes of the certification program. We cross-reference that discussion in the preamble of this information blocking proposal rather than repeat it again. The draft text of the definition in the proposed amendments to Section 102 of the information blocking regulations does in HTI-2 cross-reference the proposed certification program definition. However, as we note in preamble, commenters should be aware that we could choose to adopt the full proposed definition of business day or business days in the information blocking regulations, Part 171, instead of a cross-reference to the certification program's definitions in Part 170, whether or not we also adopt the definition for purposes of the certification program. And under that second box, we have noted, we think that this provides additional clarity, and there is, as we have proposed it, a balance, and the same days would count as business days under both the information blocking regulations and the certification program. Next slide, please. Interfere with or interference. So we propose to add a new section to regulations. This is not a definition per se. And we believe the benefits would just provide additional clarity to actors. Speaking a little bit more about this, the 21st Century Cures Act defined information blocking in part as a practice that is likely to interfere with, prevent, or materially discourage access, exchange, or use of electronic health information. And in the definition section of the information blocking regulations, so that's Section 102 of Part 171, we define interfere with or interference to mean to prevent, materially discourage, or otherwise inhibit. The proposal we have here today does not propose to modify the definition of interfere with or interference in Section 102. What it does propose is adding a new Section 104, where we would codify brief descriptions of certain practices that meet the definition of interference and interfere with within the information blocking regulations. Certain practices have been brought to our attention through a variety of ways we interact with parties interested in learning more about seeking or providing access, exchange, or use of the HI. Often, parties will ask if a practice constitutes interference, meets an exception, or constitutes information blocking. For a variety of reasons, including that we do not have binding advisory opinion authority, ONC does not opine generally on whether a given practice constitutes information blocking. However, by writing in the regulations that the practices described constitute interference, we believe this HTI-2 proposal would give actors and those who seek to interact with them to share EHI confidence that the interference with or the interfere with or interference definition is met by the practices that we're proposing to codify, and we're going to dive into them in the next slide, please. So now let's briefly look at the practices that constitute information blocking that we propose to describe in the regulation. And you'll see here that in the rule, that practices constituting interference that we propose to codify include both acts and omissions. We define practice for information blocking regulations as an act or an omission, right? Acts and omissions, both fair game. As we are looking at these descriptions, I'm not going to pause and read them all to you all. You can read them in the slides, or, please go look at them in the rule as well. It is important to remember that these are practices that interfere with access, exchange, or use. We say this a couple times in the rule. I'm going to say it a couple times here. The proposed rule does not attempt to establish facts and circumstances that would specify practices as information blocking. Whether any practice meets the information blocking definition, which you can find in Section 103 of Part 171, if you want to look it up, in a particular set of facts and circumstances, meeting that definition will turn on more than whether the practice meets the interference definition. Mike walked you through all the elements just a few minutes ago, so I won't belabor those or go back to them. As you can see, the first 6 interferences described in this HTI-2 proposal span across actions to impose delays on information sharing, electronic health information sharing, non-standard implementation of health IT likely to restrict EHI sharing, to negotiating or enforcing contract provisions to restrict lawful sharing of EHI, and contractual non-compete agreements. Some actors may be placing conditions on access, might be placing conditions on access to EHI in the actor's health IT that are unrelated to security or privacy laws and functions as an anti-competitive clause that effectively prevents certain employees or contractors from accessing, exchanging, or using EHI in other health IT. Therefore, in this proposal, we would identify a particular type of contractual clause as an interference, negotiating or enforcing a clause in any agreement that prevents or restricts an employee other than the actor's employees, a contractor or contractor's employee who accesses, exchanges, or uses the EHI in the actor's health IT from accessing, exchanging, or using EHI in other health IT in order to participate in the design, development, or upgrade of such other health IT. We note that this interference could be found in any agreement, even an agreement to which the actor is not a party, provided that the actor requires another party to include such a clause in that party's contracts with its employees or contractors. In addition, it is an interference for the actor to negotiate or enforce such a clause, again, in any agreement. We discuss non-compete clauses a little further in the preamble for this proposal in HTI-2, so if you would like to learn more about that proposal, please look it up and review the preamble discussion. Next slide, please. Here we have 2 more types of interference. One is an actor of action interference, pardon me. One of those is an actor unnecessarily requiring medical image sharing occur via copies on physical media, even though they and the requester could achieve it without going through physical media. And a point of interest for the last action type of interference described here. In a few minutes, we will talk about a proposed new requester preferences exception to the information blocking definitions, and that one of its conditions is that the requester express their preferences in writing without the actor improperly encouraging or inducing the requester to ask for restrictions on the scope of the EHI that would be available to the requester. The conditions for which the EHI would be available or timing of when EHI would be available to the requester. As shown here, the practice of improperly inducing requesters to limit their request for EHI access, exchange, or use would itself be an interference. Practices under information blocking, now we've talked about the action or acts examples. Practices under information blocking include omissions as well. We show here and include in the proposed new section 104 in the rule several types of omission by an actor that constitute interference. Among them are failures by certified API developers to publish API discovery details as required by a certification program, requirements such, condition and maintenance of certification requirements that apply to these actors, and also an interference, failure by API information sources to provide the certified API developer information that the developer needs to meet the certification program requirements for publishing API discovery details. Finally, we emphasize a point in the proposed Code of Federal Regulations and reiterate it in the rules preamble. This is not an exhaustive list of all the practices that interfere with access, exchange, or use of EHI for purposes of the information blocking definition. Things not shown here, but also meet the interference definition. Next slide, please. So, because we have not proposed to describe the full universe of practices that would constitute an interference, we believe it might be helpful to clarify that compliance with TEFCA requirements in context of TEFCA participation by a QHINS participant or sub-participant is unlikely to constitute an interference under the information blocking definition. This approach is similar to our explaining in the ONC Cures Act final rule that an actor's practice focused on educating individuals about the privacy and security risk posed by certain applications would be unlikely to rise to the level of an interference if they meet certain criteria, among them that the information provided by the actors in that case must be provided in a non-discriminatory manner, be factually accurate, unbiased, objective, and not unfair or deceptive. You can read more about that in the Cures rule from back in 2020, if you want to go refresh on that. The HTI-2 proposed rule explains that within the context of TEFCA participation, it would be unlikely to be an interference for a qualified health information network, otherwise known as the QHIN, a participant or a sub-participant in TEFCA to comply with required provisions of the common agreement and or incorporated terms of participation and standard operating procedures. As indicated on the slide, any practice between TEFCA entities that is not specifically required by the common agreement, including its terms of participation and standard operating procedures, could constitute an interference. Any practice involving or affecting non-participants in TEFCA could be an interference as well. In the proposed rule, we seek comments on the rule's discussion of compliance by TEFCA entities with TEFCA requirements as being unlikely to be an interference, and we welcome comment on the desirability of further guidance or education materials on the interaction between the information blocking regulations and the common agreement. With that, I am going to hand off to my colleague, Daniel Healy, and he's going to talk to you about updates to existing exceptions. Next slide.
Thank you, Rachel. I will continue the presentation today first by talking about our request for comment on the TEFCA manner exception. We finalized this exception in the HTI-1 final rule, and as a reminder, the exception states that an actor's practice of limiting the manner in which they fulfill a request for access, exchange, or use of EHI to only via TEFCA will not be considered information blocking when it follows certain conditions. First, we're requesting comment on the condition that any fees charged by the actor and any licensing of interoperability elements must satisfy the fees and licensing exceptions. Some context on this condition that we discuss in the HTI-2 preamble is that we state that when we propose the TEFCA manner condition in the HTI-1 proposed rule, we stated that the fees exception and licensing exceptions would not apply because we mistakenly assumed that all actors participating in TEFCA would have already reached overarching agreements on fees and licensing such that there would be no need for the application of the fees and licensing exceptions. In response to our proposal, some commenters expressed concern that because the common agreement prohibits fees between QHINs, but is otherwise silent on fees between participants and sub-participants, the proposal could allow actors to charge fees to access, exchange, or use EHI that did not comply with the fees or licensing exceptions. Some commenters also expressed that this could have the effect of disincentivizing participation in TEFCA and could cause actors to use other options of electronic exchange outside of TEFCA, where the actors believe that the fees and licensing exceptions would apply. As such, in the HTI-1 final rule, we finalized the TEFCA manner exception to include that any fees charged by the actor and any licensing of interoperability elements must satisfy the fees and licensing exceptions. We're requesting comment now on whether there are drawbacks to applying the fees and licensing exceptions, and if we should continue to apply them to the TEFCA manner exception as currently required. Second, we request comment on the limitation that carves out requests made for access, exchange, or use of EHI via FHIR API standards. We noted in the HTI-1 final rule, and as commenters have stated, FHIR APIs advance interoperability to a greater degree than IHE document-based exchange. This limitation ensures that the TEFCA manner exception does not apply when a requester seeks to access, exchange, or use EHI via FHIR API standards codified in 45 CFR 170-215, including standards that may be updated from time to time through the Standards Version Advancement Process, or SVAP. We seek comment on whether the limitation should be expanded to include exchange based on versions of the FHIR standards that are more advanced than those adopted in 45 CFR 170-215 or approved through the SVAP process. We also seek comment on an alternative approach. Eventually, all TEFCA QHENs will be required to support exchange via FHIR API standards. And in time, a participant or sub-participant could directly request access, exchange, or use of EHI via FHIR API standards from another participant or sub-participant in a different QHEN. We request comment on all the three options listed here in the rule, including whether or not the limitation should remain as it is currently. Next slide, please. We now come to the proposed updates to the privacy exception. Next slide, please. The first proposed update is to the codified definition of the word individual within the privacy exception. For purposes of the privacy exception, the term individual is defined in 171.202(a)(2). As currently worded, this text includes cross-references to incorrect citations and one unnecessary cross-reference citation. We do not propose to change the substance of the definition, but instead we're proposing technical corrections to the cross-reference citations. We note that this proposal will improve clarity for actors, and it, again, does not change the definition or how it would operate. I won't spend too much time here because I know we have a lot to get through. So let's move to the next slide, please. The second proposed update to the privacy exception involves subexception D, which was finalized in the ONC Cures Act final rule. The current subexception is available only to actors who are also HIPAA-covered entities or business associates. The current text of subexception D applies when an individual requests EHI under the HIPAA individual right of access standard from an actor who must comply with that provision of the HIPAA privacy rule. The preamble discussion of this subexception explains that an actor who chooses to deny that request on unreviewable grounds must, to satisfy the subexception, meet that actor's obligations under the HIPAA privacy rule. We propose to broaden the applicability of this subexception so that it is available to any information blocking actor, not only actors who are also HIPAA-covered entities or business associates, who is responding to a request for EHI where the circumstances and requirements for a HIPAA-covered entity or business associate to deny an individual access on unreviewable grounds apply. Making the subexception available to all actors under the same conditions in which it's available to HIPAA-covered entities makes the exception simpler for all actors. We also stated that this proposal should reduce unnecessary variation across actors and provide additional certainty relating to its applicability. We also proposed to update the name of this subexception to interfering with individual access based on unreviewable grounds to express the expansion of its availability to all actors. Next slide, please. The third proposed update to the privacy exception involves subexception E, respecting an individual's request not to share information. We propose to revise the subexception to remove the existing limitation that applies the exception only to individual requested restrictions on EHI sharing that are permitted by other applicable law. The proposal would extend the availability of the subexception to an actor's practice of implementing restrictions the individual has requested on access, exchange, or use of the individual's EHI, even when the actor may have concern that another law or instrument could attempt to compel the actor to fulfill access, exchange, or use of EHI, contrary to the individual's expressed wishes. In the preamble, we discuss concerns that actors might deny or terminate an individual's requested restrictions on sharing their EHI, specifically due to uncertainty about whether the actor is aware of and can account for any and all laws that might override the individual's requested restrictions. We also emphasize, to be clear, that the proposed revision would not operate to override other law compelling disclosure against the individual's wishes. It would, however, offer actors who elect to honor individual requested restrictions certainty that applying those restrictions will not be considered information blocking, so long as the actor's practices in doing so satisfy the requirements of the subexception. Next slide, please. So we now turn to updates to the infeasibility exception. Next slide, please. And here we have the conditions of the infeasibility exception. And as we can see, our proposed updates are to A2, segmentation, A3, third-party seeking modification use, and B, responding to requests. So we will go over each of those in turn. Next slide, please. Here we have the proposed update to the segmentation condition of the infeasibility exception. The condition currently applies where the actor is not able to fulfill a request for access, exchange, or use of EHI, specifically because the actor cannot unambiguously segment from other requested EHI, the EHI that cannot be made available, either by law, due to an individual's preference, or because it may be withheld in accordance with the preventing harm exception. The proposed expansion of the condition would make it applicable when the actor has chosen to withhold EHI, consistent with the proposed new protecting care access exception, which we will hear more about later in this presentation, and privacy subexceptions applicable to denials of individual access on unreviewable grounds, subexception D, or a health IT developer of certified health IT who is not covered by HIPAA, subexception C. And as Rachel mentioned, and as with all of our proposals, I encourage you to read the preamble where we give more examples and you can learn more. Next slide, please. We now move to the update of the third-party seeking modification use condition of the infeasibility exception. In the HTI-1 final rule, we excluded from applicability of this condition a healthcare provider's requests for modification use from an actor that is its business associate. We also noted in the HTI-1 final rule that we may consider amending the third-party seeking modification use condition in the future if doing so may be appropriate. Upon further consideration, we now propose to extend the exclusion from applicability of the condition so that it would not apply when third-party modification use is sought by any HIPAA-covered entity or business associate from an actor that is their business associate, or by any healthcare provider who is not a HIPAA-covered entity from an actor whose activities would make the actor a business associate of that same healthcare provider, if the healthcare provider were a HIPAA-covered entity. We are proposing this change because it recognizes the need of covered entities and their business associates to regularly modify EHI held by other business associates of the same covered entity. It also recognizes that healthcare providers who are not HIPAA-covered entities often have similar relationships with actors who provide services that would make the actor a business associate if the healthcare provider were a HIPAA-covered entity. And these providers may need or want a third party to modify EHI held by such actors on their behalf. Next slide, please. Next, we move to the update to the responding to requests condition of the infeasibility exception, followed by the alternative proposal. So first, we have the update here. First, some background. To satisfy the infeasibility exception, an actor's practice must meet the requirements of the responding to request condition, in addition to meeting at least one of the conditions of the exception in paragraph A of 171-204. The current responding to request condition states that if an actor does not fulfill a request for access, exchange, or use of EHI consistent with any of the conditions in paragraph A of 171-204, then the actor must provide to the requester, within 10 business days of receipt of the request, a written reason why the request is infeasible. We propose to modify the responding to request condition by establishing different timeframes for sending written responses to the requester based on the condition under which fulfilling the requested access, exchange, or use is infeasible. A couple additional points of emphasis in this proposal. The proposed revision would retain the requirement that actors communicate to requesters in writing the reasons why the request is infeasible. And as is the case under the current text of the responding to request condition, meeting the proposed modified responding to request condition would be required in conjunction with meeting a condition in 171-204A in order for an actor's practice to satisfy the infeasibility exception. So now we propose to retain the current requirement for a written response within 10 business days of the actor receiving a request where the infeasibility of fulfilling requested access, exchange, or use of EHI satisfies the uncontrollable events condition, segmentation, or third-party seeking modification use condition. We're proposing to revise the condition to offer actors a more flexible response timeline for the manner exception exhausted or infeasible, under the circumstances conditions. Under this proposal, the 10-day clock would start after the actor determines without unnecessary delay and based on a reasonable assessment of the facts that the requested access, exchange, or use can't be provided consistent with the manner exception or that the request is infeasible under the circumstances. I won't go through the benefits in detail here, but you can read them on the slide and learn more about them in the preamble as well. Next slide, please. We also have an alternative to the proposal for this update. The alternative proposal would establish maximum timeframes within which good faith discussions and negotiations must be met. And we can see the proposals for the maximum amount of time here. So under the alternative proposal, the maximum amount of time would be 3, 5, 10, 20, or 30 business days after the actor receives an initial request, or one of those timeframes for any request that does not implicate the HIPAA privacy rules right of access provision. And lastly, the maximum timeframe allowed under the right of access provision for those requests that do also implicate it. Next slide, please. And with that, I'll turn it over to my colleague Beth to talk about the protecting care access exception.
Thanks, Dan. The Protect and Care Access exception, which would be codified at 45 CFR 171-206, would cover an actor limiting access, exchange, or use of EHI in order to reduce the risk of potentially exposing patients, providers, or persons who facilitate care to legal action based on the seeking, obtaining, providing, or facilitating of lawful reproductive health care. This exception would also apply where an actor limits sharing of a patient's EHI potentially related to reproductive health care in order to protect that patient from potential exposure to legal action. The practice must be based on a good faith belief that the person seeking, obtaining, providing, or facilitating reproductive health care is at risk of being potentially exposed to legal action as a consequence of that particular access, exchange, or use of specific EHI, and that the practice could reduce that risk. The benefits of this proposed exception include offering actors certainty that practices satisfying the conditions of this exception will not be considered information blocking. It would assure patients that the information blocking regulations support actors limiting EHI sharing in response to risks that arise over time, while continuing to support patients' access to their own EHI and other appropriate sharing of EHI consistent with applicable law and patient preferences. And the exception supports continued advances in digitization, interoperability, and public confidence in the nationwide health IT infrastructure. Next slide, please. Under this exception, an actor's practice must always meet the threshold condition and then also meet one of the two other conditions of the exception, either the patient protection condition or the care access condition. The threshold condition requirements include an actor's good faith belief, a tailored practice, and the implementation of such a practice based on either an organizational policy or case-by-case determination. If that threshold condition is satisfied, then an actor would additionally need to satisfy one of two other conditions. The patient protection condition applies to practices implemented for the purpose of reducing the patient's risk of potential exposure to legal action based on the mere fact that reproductive health care was sought, received, or medically indicated. Or the care access condition, which applies to practices an actor undertakes with the belief that it could reduce potential exposure to legal action for healthcare providers or other persons who provide or facilitate receipt of care that is lawful under the circumstances in which it is provided. Some additional things to note about the Protecting Care Access exception. For the purposes of determining whether an actor's practice meets the patient protection or the care access condition requirements, we propose care would be presumed to be lawful unless the actor has actual knowledge that the care was not lawful under the circumstances in which it was furnished. For the purposes of this exception, legal action includes civil, criminal, or administrative investigations, actions, or proceedings into or against any person for the mere act of seeking, obtaining, providing, or facilitating reproductive health care. For the purposes of this exception, we propose to rely on the same definition of reproductive health care used for the purposes of the HIPAA regulations at 45 CFR 160-103. Healthcare provider is defined in 171-102. Note that we are proposing an HTI-2 to clarify the wording of the definition, but not to change the scope. Person is defined in 171-102 by cross-reference to the 45 CFR 160-103 definition of person. And please note that effective June 25th, 2024, the 160-103 definition clarifies what natural person means within this definition. You'll find all this information and more in the preamble for this new exception. Next slide, please. The second new exception we propose is the requester preferences exception, which would be codified at 45 CFR 171-304. This exception offers actors certainty that when all the conditions of the exception are met, it will not be considered information blocking to honor a requester's preference that they have expressed or confirmed in writing for limitations on the scope of EHI made available to the requester or the conditions under which EHI is made available to the requester, or the timing of when EHI is made available for access, exchange, or use. The benefits of this exception include that it offers actors certainty that if they meet the conditions of the exception, they can honor these requester preferences without the practice constituting information blocking. It would benefit any requester, including individuals, healthcare providers, and any other requester for permissible use of EHI. Finally, to the extent the actor is able and willing to do so, it allows the actors to accommodate a wide variety of preferences in comparison to even similarly situated requesters. The proposed exception has 4 separate conditions that need to be satisfied. All 4 conditions need to be satisfied in order for the exception to apply. There's a request condition, an implementation condition, a transparency condition, and a reduction or removal condition. The request condition requires that the requester express their preferences in writing without the actor improperly encouraging or inducing the requester to ask for restrictions on the scope of EHI that would be available to the requester, the conditions for which the EHI would be available, or the timing of when the EHI would be available to the requester. The implementation condition requires that an actor's practice of limiting the scope of EHI, conditions, or timing of EHI availability to the requester, or any combination of such limitations, are tailored to the specific request, which means the practice is no broader than necessary to do, and in fact does, what the requester asks for in writing. The transparency condition requires that an actor explain to the requester in plain language, verbal or written, what tailoring the actor will implement, and must notify any requester of changes in the actor's ability to maintain the tailoring. And finally, the reduction or removal condition requires that an actor must act on any subsequent request from the requester who previously requested a scope condition or timing tailoring of the requester's EHI access, exchange, or use to reduce or remove restrictions as promptly as possible. We encourage you to read through this proposed exception and its conditions in the rule. There are also several examples highlighting when this exception would apply. So this is just a gentle reminder. And this concludes our presentation on the newer updates. And back to you, Mike. Next slide.
Thank you, Beth. So I understand that was probably a lot to take in a short about 55 minutes. And to help you better understand it, we do have fact sheets available. So up on your screen, you'll see that there are fact sheets covering the entire of the rule, all our proposals in the rule, and there are 2 specific fact sheets just on information blocking. And I guess what I would hope you've taken away from today's presentation is that information blocking and how we've been approaching it is trying to be responsive to changes in the marketplace as well as interested parties, so including those being actors and then others who are interested in trying to get access or exchange EHI, whether that be a payer or a patient. And those I think no more clear example of that would be, for example, the evolution of TEFCA and proposals that we have in this rule, as well as the codification of the new TEFCA manner exception. And I think similarly, you'll see that with the clarity that we've been trying to provide, whether it was with what constitutes offering certified health IT, or what we're proposing in this rule, which is to codify specific practices that are interferences. If we can move to the next slide. The other, I guess, benefit that that you have, even with it being so potentially a lot to take in today, is that the comment period has just started. So while we've had the rule out and available for a while now, the comment period actually only began on this past Monday, the 5th, and it runs all the way through end of day on Friday, October 4th. And so if you were to go to the rule itself, there'll actually be, which is available on the Federal Register, and then they'll have a place where you can click on to submit comments, and they'll take you to regulations.gov to submit your comments. We can move to the next slide. So lastly, there's still additional, if you're interested in other parts of the rule, there are additional information for you if you've happened to miss prior presentations on specific sections of the rule. So we did one on public health, Obviously, we did an overview as well, but there was a specific public health one given, and that recording and slides are available. The recording and slides from this presentation will also be available shortly. We have to go through some processes for 508ing, for compliance, and then those will be available. And then we have an upcoming one, as you see here on your screen, just focused on the APIs for patients, payers, and providers, and that'll take place a week from today. And with that, I can move to the last slide. And if you're ever, interested in following us, we have our X handle on there, as well as feedback form where you can submit any questions about information blocking or certification program. There are what are like tiles that you can click on different subject matters, whether it be health IT safety. And then obviously there's a specific portal for you to submit complaints of information blocking that will be analyzed by obviously OIGs, provided to OIG for analysis. And we also take a look at those complaints too when it involves developers of certified health IT under our certification program. And with that, that concludes our presentation today. And I believe I turn it back to either Cannon or Josh at this point.
Thanks, Michael. And I think that does it for today's webinar. So everybody have a great afternoon and appreciate you attending. Thank you.